Rahul Reddy. Along with me is my business partner Reddy Neumann. Today we're going to discuss about filing, people who have filed EB3 applications in October, November and December of 2020 where they downgraded it. Then the USCIS comes and tells, okay, you guys we have too many applications pending in EB2. They interfiled it and still nothing happens. What can be done about these adjustment of status applications? We're going to discuss that. We're going to discuss about the Eagle bill, which was passed in the House Judiciary Committee, and what are the chances that this may get approved and become a law, and where people can get the green cards based on this Eagle Act. We're going to discuss about that, and a new update with regards to if I140 has been filed under the amendment. Though, if I140 has been filed under amendment, for the downgrade, is EB2 I140 still valid or not? There's a new update from USCIS. We're going to also discuss about if you have applied for a change of status from H1 from some other status to H1B. If you have any travel plans, how you're going to travel. We're going to update about all these things. Emily, what do you think about this? What do you think about the what people can do from EB2 to from EB2 to EB3? They filed in October of 2020, and after that, they filed. They told us, okay, now the EB2 moves forward, and then now nothing happens. What can they do?
Yeah, that's the difficult thing, because we still have this problem where you can't contact customer service, you can't put in a service request because it's not outside the normal processing time. There's practically no live customer service at this moment, which is not something that we've dealt with in the past, but it's really difficult to get in touch with someone in person to talk. And on top of that, even if you can, they'll say it's still within the normal processing time. There's nothing we can do. Contacting a senator, contacting congressmen, they're not doing anything. Ombudsman hasn't really seen much positive action there. So I think the best thing you can do right now is continue to write letters, contact your congressman, contact your senator, send that to the Public Engagement Office of USCIS, as well as to Zoe Lofgren's office, who's the congressman in California. That's all we can do, because we've exhausted every other option.
Can they refile the entire 485 application, Emily?
Yeah, if you do have your non-immigrant status that you've maintained, you can refile the 485. We've done that a number of times. We are seeing that those later filed applications are getting approved faster, but you have to be in a non-immigrant status before you do that, and make sure that if you have a child that's close to aging out, that you look into whether they will qualify under the Child Status Protection Act, so that you don't negatively impact their application.
With regards to the Eagle bill, which has been passed in the House Judiciary Committee, though, please keep watching about this bill. This bill eliminates the per country limit. It also creates an opportunity for the people to file an adjustment of status even before the priority date becomes current. That allows people to travel. They may not get the green card, but it allows people to get an EAD, flexibility in changing the employers. It also will have, aging out kids may stop there. It will allow people who are aging out, it will stop their age, freeze their age. There are a lot of good benefits. It takes off the per country limit gradually and slowly, though, so that every person who is born, no matter whichever country, will be treated equally. That definitely is a good bill, but this bill came into Congress many times, passed through the House many times, but Senate was a blocker most of the times, though. We're not expecting much resistance in passing this bill. In the House, which is the lower house, also called as House of Representatives. But when it comes to the Senate, that's where we think so it may have a problem, though. That at that point of time, we will request all of you guys to write letter. We'll draft letters at that point of time for you to contact the senators. We don't think so that it will be a problem in passing the House. So last time it passed more than 90% of the votes. It only requires 51% of the votes to get past it. We're not expecting any problem. We are not expecting any resistance in passing this bill. We would like to have this bill passed in the House, but I think so even if we are going to do some efforts, we're not going to do some efforts, it's going to be passed in the House. When it comes to the Senate, that's where we need your help. We all need to write letters, but I want you guys to wait. Let's hold on. Maybe in about 2 to 3 months, once it's passed the House, when it tries to it in the Senate, that's when we'll draft letters. That's when you need to contact the senators rather than contacting them right now. Any other opinion, Emily, on this one?
Nope. Next up, we want to talk about what happens when your I-140 was filed as an amendment rather than a new filing. So we had this situation in October of 2020 when we were talking about all of these downgrades. Some attorneys were saying, oh, we can't do a downgrade as a new filing. It can only be done as an amendment. And then you have another situation where a successor in interest has happened, where there's a change in corporate structure that does require an amendment. So some attorneys filed the I-140 downgrade as an amendment, even though it wasn't necessary to, and others had to file the downgrade as an amendment because of a successor in interest situation. That leads us to the question, now that my EB2 date would be current, can I still use that EB2 I-140 approval, or has the amendment impacted it somehow? Well, USCIS at the ALA Spring Conference has confirmed that if an I-140 amendment is filed to move to EB3, it's as if the EB2 no longer exists. So the only way to interfile in that situation and take advantage of the EB2 I-140 approval is to file another I-140 and EB2. This time file it as a new petition, not an amendment, and unless of course it's another successor in interest situation. But yeah, you do have to file a new I-140 petition. They did confirm that in a very recent conference, unfortunately.
Let's discuss about the people who are filing the change of status applications from whatever they are in. Let's say, for example, they are in F1, they are in H4, L1, and other L2 visas. They are trying to apply for a change of status to H1B. If they travel outside the country while the change of status is pending, though, they are considered to be to have abandoned the status. So if they have considered to have abandoned the status, though, their change of status will not be approved. They are technically not counted toward the H1B number. So once they come back, they will have to refile the entire H1B application. And if they refile it with the same company, they will be given an approval. If they want to file it with a different company, they cannot do that. Technically, they are not counted towards the H1B number. So we normally tell people not to travel because there's a big risk there that you will be foregoing the H1B lottery forever. There's a chance for that. Because if you lose the job, or if the company doesn't want to refile, you may actually lose the opportunity of getting into H1B, and you have to file the H1B lottery again. So we normally tend people to request them not to travel while this is. They can travel before filing the H1B, that is before June 30th. They can travel and come back and file the H1B. That's one thing they can do. The other thing they can do is that they can travel after October 1st. Which are better ways of traveling, though. But if you have any plans between now and October of 2021 and your H1B is getting filed right now for a change of status, though, we request you that you contact a lawyer, make a good plan, what you want to do before, what you want to do after, and then make a travel plan. Don't make a travel plan well in advance and then call the lawyer. Try to call the lawyer first and then make the travel plan. Anything else, Emily?
Yeah, that's one nice thing about us having this 3-month window to file the applications is you can plan out your travel and you plan the timing of the filing around the travel so that it's not as big of an issue. So you can avoid abandoning your change of status request.
As we have given the draft letters for people, while the Congress is working on the legislation of removing the per country limit, we have seen this kind of things getting hit so many times. It comes very close, it fails, it comes very close. There are things that the administration can do while the Congress, which they call the Parliament as Congress in the United States, while the Parliament is not doing much activity, I want you guys to write letters to the administration. There are some things that they can do to expedite or to move the priority dates much faster for all the people. The one thing is that they can stop counting the the dependent numbers. So that the people out of the 140,000 green cards, 60% of them will go to family members. Only 40% of them will go to the main members. If they stop counting the family members, though, then it will go to from 140,000 to almost 300,000 green cards. They can do that. I mean, the law is, when the law is passed, it's not, they didn't set that to count the family member. They didn't set not to count the family members either. So it is up to the administration to implement it. So we request all of you to write letters to the congressman. We have given a draft of it. We also have given a provision where they wasted 60 to 70,000 green card last year. The projection is that they're going to waste 160,000 green cards this year if they don't act properly. These 160,000 most probably will be given to the countries that are using mostly, which is mostly Indians. So they're going to waste approximately 15 years of green cards if they don't act properly though. So I request you to write letters to the congressman. The congress people need to know that these many number of things are getting wasted, and they can force the administration to act on it. So please keep writing letters to the congressman. We have given a draft, and we are going to promote only if somebody has written letters. That's when we will, if you have written letters to the congressman, we are going to try to answer your questions. So when you're posting a question to us, let us know that you have already written the letters though, because we want you to act on it. If you don't want to act on it, we don't. What's the purpose? You'll be coming to this to this YouTube and Facebook for the next 30 years or even more. You don't want to come here. You want to get the green card. If you wrote the letters, then you have done at least the part what you can do. Let's see what the administration can do. Go ahead, Emily.
All right, getting to questions. Girish has written his letter and he wants to know, USCIS says that there's no need for additional staffing at the National Benefit Center or the field office. Will it not overload these service centers if cases are moved from Texas and Nebraska? Yeah, that's a great question, and that is a big problem that we are concerned about. Yeah, right now the National Benefit Center seems to have the resources to approve, 30,000 in a quarter, and that includes those that are done at the field offices. But now we're talking about sending 100,000 applications to them. Yeah, I do fear that they're going to be overloaded, and we've had past
Even if they do it
experience.
30,000 every quarter, Emily, that's only how much? 130,000 green cards every year.
Yeah.
So that means that they're going to waste 160,000 green cards. Sorry, I said 150. So.
Yeah, and we've had past experience with the field offices taking 4 years to process 485s, and they were all threatened to be fired because of it. So we're very concerned that we're going to get into that same situation where the field offices, where they have no, I guess, motivation to process things quickly, and we're going to see these green cards wasted, even though they're trying to transfer them supposedly to get them processed faster.
Question, is it mandatory, Vivek has written letters, thank you very much. Is it mandatory by law for employer to cover the H1 and H4 visa fees charges? For the H1, legal fees and the filing fees, employer has to cover it. It's mandatory by law. For the premium processing, it depends. It's optional depending on is the employer who wants, employee who wants. So it's not mandatory to cover the premium processing. When it comes to the H4, it's definitely not mandatory for the employer to cover the H4 legal fees or the filing fees. It can be either done by the employer or it can be done by the employee.
Sweet Seller has sent letters to their Tennessee congressman and wants to know if a case gets moved from Texas or Nebraska to the National Benefit Center, would it immediately move to a field office, or will it sit at the NBC for a while before moving to the field office? We don't have a lot of insight into these inner workings. It sounded to me like they have these files uploaded and the field office can access them without the file actually moving from the National Benefit Center to the field office. I got that impression. I can't say for sure that's what's happening. And we don't know how quickly they're going to be assigning these cases to different field offices once the National Benefit Center receives them. Hopefully they've got a plan in place, but I'm not holding my breath.
Siri says this question, my company lawyer only wants to file interfiling rather than filing a new one. How can I convince them? Well, you can show them the video that we sent. We did it in the month of March, early March. Sorry, we didn't do it in early March, sorry. This is somewhere in April. We did it on interfiling and refiling. Send the video to him. That's all you can try to convince him.
Uma wrote letters and wants to know if there's any tips on how to ask questions to Emma or the phone agent so they give you accurate information, and is there any issue if you contact them frequently? So with the phone agents, really the level 1 officer that you're going to be in contact with can literally only tell you what the online case status says. So there's not really much point to calling. The only thing that you can do when you call is if it's outside normal processing time, then they will put in a service request and you'll hear back from them on that. But just to find out what the current status is, calling customer service is not really helpful because they literally just tell you what you can see online. As far as chatting with Emma, I don't have a whole lot of experience with it. I've been able to do it, I can say once, and it was not a very pleasant experience. So I haven't attempted it since then. I got cut off 3 different times, and by the time I got to the last one, I got the most unhelpful answer ever and immediately ended the chat session. So I don't have any tips on that. It does not seem to be a good option.
Maybe it doesn't like girls.
That could be.
VK has this question. He wrote letters to the congressman. Thank you. H1B transfer application has been filed with the receipt notice. Can I work for 2 companies at the same time for a couple of months? It was not a concurrent filing. No, you cannot work for 2 companies at the same time unless the second company has filed a concurrent filed application. Since you have clearly mentioned that you did not file a concurrent application, you should not work for 2 companies at the same time.
Saravana did write letters, and he says, I have a Canadian visitor visa. My H1B requires stamping, but a valid I-94. Would there be any issue traveling to Vancouver for a few days and returning without any problems with CBP at the border crossing? So if you have a valid I-94 and an expired visa stamp and you're traveling to Canada or Mexico for less than 30 days, you do not need to get the visa stamp, and you should not have any issues returning through the port of entry under automatic visa revalidation. You can go to the CBP website and search for automatic revalidation and print out. They have a little article about it that explains who qualifies for it and that it does exist. Keep that with you in case you run into an officer that is giving you a problem. But a lot of people use automatic revalidation, generally don't have any problems, particularly if you're traveling by air. It's been very smooth.
Surya Teja has written letters. Thank you. Tax audit, will it cause any problem on the immigration issue? No, if it's just an audit, it's not going to cause any problem. Just to tell you a simple example, the President Trump is under tax audit, and he has become a president. He is out of president. His tax audit is still going on. So if you can become president, no, there is absolutely no problem for you to get the green card. You're good. Green card, H1B extension, H1B stamping. We don't see any problem if you have a tax audit.
B has written letters to congressmen and says the EB2 priority date is December 2011, filed the 485 in December 2021, stuck at Nebraska. Biometrics are done, but no EAD and AP, no update, not even an update saying the biometrics have been updated. What do I do? There's not really anything you can do because that is still well within the normal processing time. We are seeing some action on December 21 cases in the National Benefits Center, but the Nebraska Service Center is still working on cases from 2012. They're not even getting to 2020 yet. Unfortunately, there's not anything that you can do. Perhaps once your EAD and AP have been pending for 6 months, if they're still not approved, litigation may be an option to get those interim benefits. Not necessarily to get the green card faster, but we have had success with litigation to get the EAD and AP once it's been pending for 6 months.
Sumant Kanapuri has this question. Perm filing delayed, less than 365 days left in the 6 years of H1B. What are the options there? One thing is that if you spend a lot more time outside the country, you may, as you already know, that the 6-year limit can be extended. That's one thing that you can do. If you have a H4 plus EAD option, though, definitely choose that one. You can consider that option too. Also, make sure that if by any chance, if these 2 options don't work, if you have, make sure that the company can still file the permanent I-140 even after you complete your 6th year. Even if you're in India, Canada, or whichever country you are in, they can file and get the I-140 approval and bring you back on the H1B without subject to the cap though. You can still consider that. So make sure I would choose the first option of spending as much as time outside the country. And if you don't have a passport stamping, there is something called automatic revalidation, where if you have an I-94 valid though, you can go to Mexico and stay there for under 30 days and keep coming back. I have some people, I told them, hey, keep going and spending time there. And there are, because of the COVID restrictions where people have to come to Mexico and from there they have to come here, there are some places that just cater to Indians, where Indian food and other things are available. You can go and stay in those hotels for 25 days and come back, and visit again and come back. In that way, you can extend the 6-year limit. So please watch a video that we have made on that, just exclusively perm, 6-year expiring perm, not I-140 not approved. So please watch that video. It's about 20 minutes video made by me and Emily.
Rajesh has a downgrade application pending and refiled in EB2 and wants to know if he can use the advanced parole that came with the first 485 even while the EB2 application is still in process, and does it negatively impact the EB2 application? We don't have any guidance from USCIS on this. I think there's a strong argument that could be made that an AP is valid as long as there is a pending 485 and it's not necessarily tied to a specific 485. Especially given the fact that in some of these refiles, they have closed the second AP filing and said you don't need it because you already have an AP. Have I tested out that theory? No. So there's some risk there. The biggest risk would be denial of your second 485, but it would not impact your first 485.
Rajesh Nair has written letters to the congressman. Thank you very much. His lawyer wants to file I-140 and for EB2 I485. Prior date is current. Should he file concurrently or should he file it standalone though? If you file it concurrently, it will go to Texas and Nebraska Service Center. And once the I-140 is approved, if the final action date is current, God knows when they're going to move it to National Benefit Center and when your application is going to be approved. So definitely filing an I-140, getting an I-140 approval, then filing the 485 is a better option for you. But here is the problem, Rajesh. Right now, your priority date is current for the month of April. How do you know it's going to be current in the month of May? So if you file an I-140 right now, and then guess what? You don't get the receipt notice, and the priority dates move back in May. What are you going to do? What are you going to do? You will have a problem at that point of time. There are creative solutions for it. So what I would normally do at this point of time is to wait to see what is going to be the priority dates in May, which is going to be, and another person was asking the question to me, that when would the priority dates for the May will come in? Most probably by end of this week. So I will prepare the I-140 for you. I will prepare the 485 for you. I will watch the priority dates of May. And if the priority dates of May go back and it's not current for you, I'm going to file I-140 and 485 together, even though you will end up in Nebraska or Texas Service Center. But if the priority dates are going to be current in the month of May, I'm going to file an I-140 right now, and and then in the month of May, I'm going to file the 485 for you. In that way, your application will end in National Benefit Center.
Rods has a downgrade filed in 2020. Fingerprinting was done. Interfiled the medicals as well as interfiled to EB2 in February 2022 and wants to know, I have a job offer now. Is it okay to change the job? Will AC-21 kick in? Based on the most recent guidance from USCIS, you have to wait 180 days after your interfile in order to be eligible to change jobs and take advantage of AC-21. So we don't think there is any authority for that interpretation, especially where your EB3 and EB2 are with the exact same company, exact same labor certification. Probably something that can be litigated, but do you want to be the person to get your 485 denied and then have to litigate it because you moved jobs too early? That's the risk you take right there.
Vikas Gupta, his priority date, he has an I-140 approved. He wrote a letter. Thank you very much, Vikas, for writing letter to the congressman. Your I-140 is approved with the previous company, and the priority date is current. With the current company, they haven't started the perm process. What are your suggestions for me? Drop everything, go back to company A, and have them file the 485. If that's possible, should do that. Now, even though you're working with company B, company A can still file the 485 application for you. That's if the company A wants to do it though. So whatever the company A wants you to do it, comply with it and file the 485 application, and you will achieve the freedom in 6 months though. That's what I would like. So you will have to negotiate with company A. Even if the company A has withdrawn the I-140 application for you, they can refile the I-140 and still file the 485 application for you. So there are many possibilities. The ball is in the company A's court that has the I-140 approval. And you have to play what they tell you to play. There is a video we made on it. Please watch. It's made about 3 weeks ago. That my I-140 is approved with company A and I'm working with company B. Can I file 485 application? Please watch that video. It's a very good video that gives you more instructions for you.
Rajiv has written a letter to his congressman and has 2 485s filed, one in EB5, another in EB2. Also has an approved I-140 and EB2, and the priority date's been current for the past 9 months. EB2 ended up going to the California Service Center and then transferred to the National Benefit Center. Then they said they were going to send it to a local office, and now it's at Texas Service Center. Wants to know what is going on with moving it to different service centers. Yeah, we do see that from time to time in some cases, particularly when there are multiple things pending. And unfortunately, there's nothing you can do about it, and there's no rhyme or reason to it. I think it just keeps getting bounced around until they find the right jurisdiction over it. It's very possible that it's going to get transferred from Texas back to the National Benefit Center under this current policy of doing that. So unfortunately, yes, it does happen, and there's no way to stop it from happening or make sure it goes to one place over another.
81 Park as his question. He got the 485. He filed the 485 application with the company that he was not working. He got the green card. Now, is it mandatory for him to join the job? Does he need to work for 6 months? If he doesn't work for the company, will it cause any problem for the citizenship? The answer is no. You don't have to work for the company that you got the green card for, even though you have never worked for the company though. There is a clear memo from USCIS that says that that even if you don't work for the company, they should approve for the green card. It's just the purpose for which what they are giving the green card is a concept that there is a job offer. It's not the actual whether you're doing the job is irrelevant. Is it a genuine job offer? The genuine job offer was there. You probably wanted to join that company, and now after listening to Rahul and Emily, now you change your mind. Nothing wrong with it. Nowhere, no naturalization was ever denied. I don't know where they come up with these rumors. I don't understand. It's just like the way when in October of 2020, remember we told all the people, file them as a new application. Guess what? Most of the lawyers didn't do that. Now they are suffering because they didn't file as a new application. Now in this case, 81 Park, you are in a good position. You don't have to join, and you will not have any problem whatsoever at all in getting this naturalization or citizenship when the time comes in.
VK wrote a letter to his congressman and wants to know if can I work on the H-1 transfer receipt with a new employer while also being employed at the current employer until the transfer is approved for a couple of months. This is not concurrent. No, it's a transfer. So you either work for the new company based on the receipt, or you stay with the old company until the transfer is approved. You can't work for both at the same time unless the new company is filed as a concurrent employment.
Krish has this question, can we interfile from EB3 to EB2 if the filing date is current? The answer is yes, you can. However, though, as a practical matter, we do not suggest you do though. Because what if the EB3 moves forward? And you can say, oh, EB2 is moving forward much faster. Well, you never know which moves forward. In October of 2020, did we expect EB3 to move forward? So if your filing date is current and we are filing saying that please approve the green card, they can't approve your green card on the filing dates. It has to be the final action date. Then EB3 moves, then what are you going to do? File a EB2 to EB3 into filing again? So as a suggestion, we still recommend to wait until the final action date become current. But it's not illegal though for you to interfile. It's perfectly legal. It's just a practical suggestion. Another question that comes from Praveen on this interfiling. How do we know if interfiling is accepted? Is it 180 days wait is over? We never know. We will never come to know if the interfiling is accepted. The only time we will come to know interfiling is accepted is when they approve the green card. That's all. There's no, even after we get the 485J receipt notice, is it that means that interfiling is accepted? Now they're going to take you under EB2 and approve it? We don't know. It is discretionary for them to accept the interfiling. It's not mandatory for them to do it. So we will never come to know until they actually approve the green card.
Mufadal has a company applying for the I140, but he doesn't have any work experience except then with his current company. Before that was his master's and bachelor's, and he wants to know if he will have to change jobs for the green card process. Possibly, but not necessarily. So you're thinking that you can't count experience gained with your current employer in order to show that you meet the experience requirements for the position. That is the main basic statement. Number one, you have to look at what is the company saying the minimum requirements for the job are. If they're just saying the job requires a bachelor's degree and no experience, or a master's degree and no experience, then that company can sponsor you, because you don't have to prove that you have any experience prior to joining them. Another option is if your experience that you did gain with the company was in a different position, a substantially different position, meaning at least 50% different than the job you're actually being sponsored for, you may be able to count that experience even though it was with your current employer.
Sai is planning to refile the EB2 application. Is it best to interfile before refile? If you're refiling the EB2 application though, I would not interfile. Here is the reason though. When you refile the application though, you will be going in two lines. One is EB3, which you're already in, and EB2. If you interfile, you practically are moving in both of them in the same line. So what if EB3 moves forward? Well, you'll be in trouble. So if you're planning to refile though, I definitely recommend you do not interfile to EB2.
Kieran wants to know, if I get the EAD and AP and then I lose the job, what happens to my status, especially if I have not used the EAD yet? Can I stay in the US for the 60-day grace period and then find a job using EAD? So there's two different things that you have to worry about. Number one is your non-immigrant status. If you're intending to maintain that, then you do have to, you have the 60-day grace period in order to find the new position and file an H-1 transfer. Or you could start using the EAD instead from that time period. But the other issue is your green card process. Do you qualify for AC-21 yet? Will you have the valid job offer by the time USCIS asks for it? So that's another issue to worry about. So to say that, yes, you have 60 plus days to figure out the new job situation, possibly yes, for your non-immigrant status, but possibly no for the green card process. So if you're in that situation, you should definitely contact a lawyer to discuss what your options are for the green card process to be able to continue.
Karthik, he has written letters to Congressman. Thank you very much. That's a very good noble step that you've done. USCIS he's saying that US is pretty clear not to refile. They've pretty acknowledged that they would make the situation worse. Is refile is still recommended though. First thing, they didn't made it very clear for not to refile. They requested us not to file. They recommended not to file. But here is where the practical problems are coming, Karthik. The applications that were filed some in October of 2021 as compared to the October of 2020, applications filed in October of 2021 are approved way faster than the ones that were approved in 2020. So that's the reason most of the people are preferring to refile though. They're recommending us not to refile, but at the same time, what are they doing? They are adjudicating the cases that we filed in October of 2021, because most of the cases that we filed in October 2021 are straight applications and they went to the National Benefit Center, they got approved, while the ones that we filed that were lagging in Texas Service Center are still pending there for a long period of time. There's another person who was asking a question, wrote letters to wrote letters to the congressman, and they're asking, have you seen more cases that have been getting transferred from NBC and Texas Service Center to National Benefit Center? We are seeing some cases, not all cases, getting transferred. It's definitely a very good indication that they're transferring National Benefit Center. The USCIS, when they release the press information though, they are telling that they are transferring approximately 1,000 cases every week to the National Benefit Center. The last inventory taken was about 180,000 cases are pending there. If they are going to 190,000 cases are pending in the Texas Service Center and the Nebraska Service Center combined. So they're going to take about 180 weeks. So that's approximately 180 weeks is what? 12 years or so, more than 10 years. I can't even count the numbers, guys. Approximately, no, 180 weeks is, they're going to take 15 years. Is it right?
Wait, 3 years.
No. They're going to take
52 weeks.
Sorry, 52 weeks. They're going to take approximately 3 years to transfer all these cases though. But the cases that are recently getting filed are getting approved. That's the reason why, Karthik, I'm responding to is that some people are preferring to refile rather than interfiling, because we haven't received most of the receipt notices that we filed in February 2nd week, leave alone any of the approvals though. The cases that we refiled are getting approved, but the cases we interfiled, nothing is happening from them.
Anil has an H-1B extension filed March 14th at the California Service Center in normal processing, but the receipt notice has still not been received. He wants to know how long it takes for the receipt. Is there a way to file premium processing without the receipt number? And he says he's stuck with the 485 filing without the receipt. So yeah, there are some delays in the receipts, but generally not that much. That's been almost a month. Something unusual is there. I would definitely be asking my employer if the filing fee check has been cashed. That should have been cashed by now if everything was properly received. And then usually, but not always, you can get the receipt number off the back of the cashed check. Using that, you can file the premium processing upgrade. If you don't have the check cashed yet, there may be a problem and you may need to talk to your employer and their attorney about getting that refiled, especially if your status is expiring soon. As far as being stuck with the 485 filing without the receipt, I'm not sure that's really a problem for filing the 485. Now, if your H-1B has already expired and you're planning to file the 485 with the receipt, yeah, you can do that. But technically, as long as your H-1B expired less than 180 days ago, you can still file the 485. You can always give them the receipt later or send in the approval notice later. So I don't see that stopping the 485 filing.
DM is saying that his EB2 interviews happened, 135, no decision. I would request that you contact the Ombudsman's office. Please type in Ombudsman, Department of Homeland Security, and there's a case assistance. You can do it online. You may get a help from them and have, it may force the officer to adjudicate your case sooner.
Arun wants to know, with a new employer, when you file the supplement J, what I-140 number do you do? The EB3 or the EB2 I-140 if you're changing employers within 180 days after the interfile? I think I would put the EB2 one because you have already requested USCIS to transfer your case from the EB3 to EB2, so we have to operate under the assumption that that's happened. And so now you're asking to use AC21 portability based on the fact that you're in EB2 180 days after you did that interfile.
Nanda has this question, can you do business on H4EAD? Absolutely, we can do anything that is legally allowed to do. Anything that's legally allowed to do. You can flip a burger in McDonald's, you can own a McDonald's, you can be a Microsoft CEO. Or you can do any business.
Anoop says, my online I-94 shows that I traveled on a particular date, but I didn't. Is it common? I wouldn't say it's common, but it's not uncommon. It does happen, and there's nothing you can do about it. CBP will not correct it, even if you bring it to their attention.
Sunil has this question, can I go for stamping while my amendment is in progress? We do not recommend though, because you're having USCIS pending there and then you're going for stamping. I would recommend if the amendment is pending, do the premium process, get it approved. That's going to be an easy solution for you.
Harsh says, if the employer files for an H-1B extension while I'm outside the U.S., does USCIS approve it for consular processing by default? Yes, if you're outside the U.S. on the date the H-1B extension is filed, it can only be approved in consular processing. You're not eligible to extend your stay because you're not in status in the U.S. There's nothing to extend.
Wrote letters to Texas, that's Congressman, I guess. If I switch the job on the T2 of the GC, doesn't that show a fraudulent intent? Well, the intent has to be from the employer, though, not much so from you. That's a different aspect that we can discuss, though. As long as the employer intention, the job is open for you, that's fine. We don't see any fraudulent intent of you, though. We don't see, absolutely, and we have never come across that thing ever questioned, ever, though.
Abhijit has written a letter to Congress and says his GC EAD has been pending for more than 180 days. He's about to lose his job in 2 months. Expedite request from the congressman was denied. There must be a way out of being held hostage like this. Yeah, it's a really tough situation, and it's impacting more and more people as these initial EADs back from October 2020 were only granted for 1 year, and you can only file so far in advance. You only get a 180-day auto extension. What do you do when that runs out and you still don't have the new EAD card? I think litigation is a great option there, especially where your EAD application has been pending for 6 months. I would recommend reaching out to Stephen Brown in our office at stephen@rnlawgroup.com.
Surat has written letters to the congressman in Tennessee. Can the employer file a H-1B extension premium processing in the third year, after the 3 years? He's in India on vacation. My main issue would be that when is your H-1B expiring, though? If the H-1B is it would be better that you are in the country, you come back in the country and they file the extension. Because if you're outside the country, they're filing an extension, you won't get an I-94 with it. So it's a bit confusing the way you're planning to do is that if you have the validity, it's better that you come here, they file the extension. That would be much better, though.
Rohit wants to know, what's the best strategy to move from a nonprofit organization to a for-profit organization if I'm on a cap-exempt H-1B visa? Well, to move to the for-profit and you're on cap exempt, you have to be counted in the cap, so you have to go through the lottery. What happens if you weren't selected, or if you were selected but your petition is not going to take effect until October? There's an option where you can actually work concurrently for the for-profit and nonprofit at the same time without the for-profit going through the cap. So your for-profit employer would file an H-1B for concurrent employment to allow you to work for both employers at the same time, and you can keep doing that until you actually get selected in the cap and get your for-profit H-1B cap subject petition approved.
Ravi has this question: how many days can I be unemployed after losing the job in I-485? I-485 has been pending for more than 180 days. Ravi, there are other creative ways of being employed. Sometimes, you can have your wife employ you. She can start a company and employ you if she's on ED. There are many different ways you can join some company temporarily and then move on to a different company, though. So I would like to minimize the risk, because recently they have increased the amount of RFEs that they've issued asking the 5 years employment history. So definitely I would like to keep that as minimum as possible, though. Now there are ways to argue and get the things approved even though you have an unemployment period, though, for a long period of time, because it's just the offer of employment. But the USCIS may be reluctant. It may cost you a lot more money, legal money, rather than having been employed. If you're not getting employment with Facebook or YouTube or whatever company, just join some small company rather than actually not having employment at all. That would be in your best interest. But if you still can't find a job, it may be better that you consult a lawyer so that you can see what are the other creative ways that they can come up with.
So Robbie wants to know, what's the order in which the field office processes the application? Is it based on the priority date or the received date? There's really no rhyme or reason to it. I think that when the field officer is assigned a certain application, they're going to open it up and say, is the priority date current? Is everything there? And they're going to adjudicate it, even if there are 10 other applications that were filed before this one that haven't been assigned to them, even if this priority date is actually later than other priority dates. So it's really more about what cases get assigned to that officer, and what's on the top of the stack. Is the date current? All right, I'll work on that. I don't think they're going to rearrange their cases based on received date or priority date or anything in between.
DM has this question: can he change the company? His interview has been completed, but the 485 is still pending. Yes, you can change the company. However, though, I'm a bit reluctant in filing the 485J supplement. Unless there is an RFE, I will not do anything. I will just not do anything. Just change the job, make sure that the new job is in the similar profession as your current job.
VJ says, what is USCIS doing with all the interfiles that were sent to the California address? Great question. All those applications are... Yeah, it ends up on the floor of the mailroom as far as I can tell.
I don't know. That's the only thing I can think of.
Yeah, you're right. All those applications are GC ready. They should jump on them and start processing them. They told us to do this. They said, we have all these green cards in EB2. Hurry, submit your interfile to get into EB2. And then they sit on it. It makes no sense.
Harish Kumari has this question. Refiling the EB2, can I travel to India while refiling application is pending though? Thanks for writing the letters to the congressman. Yeah, you can travel to India. I'm assuming that you're coming back on a H1B or H4, then you should not have any problem in traveling when the 485 is pending. Your advance parole may be denied, but you can always file it again.
B has a great question. Litigation sounds harsh action on USCIS. Can they act negatively and reject or take adverse action because we sued them? Well, they deserve harsh action, in my opinion, but it is your right to sue any U.S. government agency who is failing to act. There's a statute passed by Congress that specifically allows for anyone to sue a government agency when there is an unreasonable delay in what they're doing. They're not allowed to retaliate against you, and they don't retaliate against you. We've been filing lawsuits for years. We've dealt with all of the H4 and EAD delays for a long time. Now we're working on the EAD and AP delays. Never had anyone have any kind of negative response from USCIS because of it, and that would be illegal for them to do that, so they don't do it.
Indian guy from YouTube says he contacted a agent with the 485J, wait for 60 days before contacting. You contact for 60 days, then they'll say, wait some more time. That happens a lot of times. So yeah, well, there's nothing else we can do, I guess.
Manoj, his son's H4 is approved under his wife's H1B, and he wants to know, can me and my son go for stamping in India and get my son's H4 stamped under my H1B? Absolutely, no issue with that at all. So your son is could actually apply under either of your H1B approvals. It all depends on which one he submits the DS-160 under, but yes, that'd be fine.
Emily, I need your assistance on this. I'm going to answer this question, but I want you to correct me if anything. He has an EB3 I140 approval and an NIW EB2 approved. Can he interfile though when the priority date is EB2 priority date is current? I'm thinking he should not interfile. His EB3 is firm labor, EB2 is national interest labor.
Trying to think if there's any specific restriction on that though.
And that's the reason I asked your opinion, because I'm thinking that the job duties may not be similar, because this is a national interest waiver that is.
But they don't need to be. As long as you have an approved I-140, you can always interfile. Like back in the old days when we would have the EB3 I-140 approval, and then 5 years later we file the EB2 I-140, even with a different company.
I'm still being more defensive of refiling for this guy if he maintains a non-immigrant status though, rather than filing a national interest waiver or interfiling. That's my opinion, but I think so. That's the reason I'm not clear. That's the reason I asked you if you have a different opinion. You seems to be that, yeah, you can do interfiling.
Yeah, I think you can do it. Whether it's going to be the best way to proceed, maybe that's a different question.
Can I file EB1C having H1B? What are the chances of approval? Well, first of all, EB1C typically is a very hard thing, especially if you are an H1B. I'm assuming that you might have already worked for the Indian company for more than 1 year though. I will test the waters by filing an L1A first, because the similarities for L1A approval and EB1C approvals are more similar. So instead of filing an EB1C, I will test the waters with a L1A, converting into L1A to see if that passes, and then it'll be easier to file an EB1C. That's what I will do. Now, I know it's a costly affair, but it gives a very good occasion to test the waters, and also for the EB1C adjudicator, if the L1A is already approved, he's more comfortable in approving the EB1C as compared to approving EB1C directly from H1B.
I'm trying to search for
Is
letters.
continuation of employment mandatory when you are in the adjustment of status? There are some loopholes that we can argue that it's only the offer of employment, not the actual employment. So we can defend you in those things. Lawyers are there, and you keep on paying them the money, and they will try to argue in your favor. Even for the people who have been accused of murder, there are lawyers. I mean, there will be lawyers, and we are there. So if there is a discontinuation of employment for the main person, though, it may, the adjudicators may feel very reluctant in approving the 485 application. So I will try to minimize the unemployment as much as possible. Now, if you are forced for an unemployment, yes, we can argue saying that it's just the offer of employment, it's not the employment by itself. We can keep on arguing on those things. We may win, we may lose, but one thing is for sure, we make money either way. Whether you win or you lose, we make money. But if you try to avoid the unemployment, that way, we lose, you win.
Harry wants to know, does it take 4 to 6 months from the final action date being current for the employer to get notification from the NVC to proceed with consular processing? Well, before COVID, it's actually the dates for filing when the NVC starts processing the cases. That's where the dates for filing came from. Those are the dates that NVC starts acting on the application to start gathering the documents so that you'll be documentarily qualified by the time the final action date becomes current. Now with COVID, there's delays everywhere, so there's no rhyme or reason as to when the NVC will contact people based on when the final action date is current. It's all dependent on what's going on at the NVC and what's going on at the particular consulate, what kind of delays are being faced because the consulates have been closed for so long.
Question that gave, I wish they would give, he wrote letters to the congressman, that is B. I wish USCIS will charge $1,000 to give a tour for what happens inside the USCIS. That will be a very good idea. Well, I took the tour though, in the Texas Service Center though. So I know what happens when I went there. It was a huge facility in Texas. I'm not supposed to disclose the location because we have signed a confidential agreement where exactly it is located at. It is definitely Texas Service Center is located in Texas. That's all I can say. And it was a huge facility. The mail room, they call it as a mail room, and they showed it to me. It was full of people. They're all contract employees, not direct employees of it. Every document that was coming in, they're opening the mail, there are boxes of mails, they're opening the mail and they're scanning all the things what they are telling, and they're trying to issue the receipt notices though. The facility was as big as a Walmart. It's a huge Walmart just to open it. They were telling us that the huge truckloads of mail come in every day. When they actually moved the Texas Service Center to that particular place where I went to, they went to the post office. The guys was telling, oh, you're going to get a lot of mail. And the post office would say, yeah, okay, we'll handle it. Then they said how much of amount of mail that they get, like truckloads of mail. I was like, what? Then the post office itself have to improve their facility to handle the mail of the USCIS, because normal post office can't handle the mail of the USCIS. So yes, it was a large, huge office though. Now that's when we went to the initial facility, it was a mail room. The mail room was huge like Walmart, as I said. Then they took us to the the adjudicator office. The mailroom was full of people. They're all working. I guess they're contract workers. They're working. Now, then we stepped into the adjudicator's room. And then we even saw the files of the people too. And there we found all empty desks. Out of 100 desks, only 10 people were there. So where are the adjudicators? They said they work from home. And this is not at the COVID time. This is way before the COVID time. I said, what? These people work from, yes, they come once in a week, take the file and go to home and work. Oops, we didn't know that these files were being taken to home and they work. Yes, they take it to home and then work. Then why are you guys making them work from home? Well, we don't have enough facility to work in our facility. That's the reason they don't have a particular desk that belong to them. So they go to home to work. Wow. So they don't have enough place to work here and they take the file. They come back every week and put the files, put the old files and take the old, give the old files and take it. Yeah, okay. So it was definitely eye-opening for us the way they work it. This was Texas Service Center that I went to. When I spoke with my other colleagues who have visited the other service center, it's mostly similar ground, similar place where it is. We saw the contractors definitely work very efficiently than that of the employees though. I mean, they're like, oh, coming whenever they want to, go whenever they want to. I don't know how they are supervising these people, but that's how the facility was there when we went to. We had a meeting with the adjudicators of the H-1B. We had a meeting of the adjudicators with the I-140, we had a meeting adjudicators of the adjustment of status. They're all different departments though. They're being handled by different officers. The officer that does the handling of the I-129 H-1B does not do the I-140. The one that handles the I-140 does not do the 485. I don't know if anything has changed recently, especially when we started filing these downgrade applications, because we file I-140 and 485 together. Is it going to be the same officer or not? We don't know. They haven't done any tours recently for the service centers, but if there is any tour, we are going to go there and we're going to inform you guys about what goes on there. But unfortunately, there is no tours for the outside people. It seems only lawyers are allowed in the tour, at least the tours that I went to.
Jaggies wants to know, does using the AP to travel mandate using the EAD for employment, or can we continue to stay in H-1B status? It's a very common question we get, and we do have an article posted on rnlawgroup.com written by Stephen Brown about this very topic. It's a little questionable because there's an old memo that says when you re-enter on AP, you can extend your H-1B status, and the approval of that extension of the H-1B puts you back in H-1B status. Well, then the question becomes, what's your status from the time you entered on AP till the time you get the H-1B extension approved? Are you an H-1B or are you an adjustment of status? And the memo does not specify on that. And actually after this memo, there was a regulation issued that didn't cover it at all. And the whole reason we had the memo is because they were getting ready to publish a regulation to cover these issues. And then when they did finally publish the regulation, it didn't cover these issues. So if you want to get back into H-1B status after traveling on the advanced parole, one thing you could consider is after you take your big trip and come back from your home country, take another trip to Canada or Mexico, assuming you have the valid I-797 approval of your H-1 with the I-94 on it. You can use automatic revalidation to come back in and get back into H-1B status now, rather than waiting until you file that extension to get back into H-1 status.
Letters written by Raj. Thank you very much for the congressman, writing letters to the congressman. So how long it's going to take for the regular receipt notice? My lawyer intends to file a premium processing after the receipt notice. The regular processing is taking anywhere between 2 weeks to 5 weeks to get the receipt notice for the I-140. I would say 10 days to 5 weeks, sorry. Anything else?
Let's see. Amanprit has a question. Is it electronic filing for cases with USCIS, or does the attorney have to print and send documents by the mail? We have to print and send documents by the mail for pretty much everything. The few cases where online filing is allowed, you can't do it with an attorney. You have to file on your own. So for attorneys, we file every single thing with USCIS by mail versus the Labor Department, where we do LCAs electronically, we do perm electronically, we do the prevailing wage electronically. We can even upload an audit response in a perm case. We can file an appeal electronically in a perm case. Not with USCIS.
Even with USCIS, where the electronic filing is there, it's very limited. Those things are. Not all the things can be filed electronically. Very limited things are there. Anything else, Emily?
All right, I think we're out of time for today. Thanks so much for joining us. Be sure to go on to rnlawgroup.com and you can click on news to see all of our latest articles. And you can also sign up for our newsletter that we send out every Wednesday. So we'll be sending that tomorrow to give you all of the updates.
And please do write letters to the congressman. And next week or anytime you want to ask a question, if you have written letters to the congressman, we're going to promote you. We're going to answer your questions before we try to answer other people. Thank you very much for tuning in.